University, Dehradun would like to welcome you all to National Webinar on Commercial Court Act 2015. For today's webinar, we have with us a renowned advocate of Supreme Court of India, Mr. Nitin Kumar Gupta. I would like to take a privilege to extend heartwarming welcome to keynote speaker of the webinar, Mr. Nitin Kumar Gupta. Thank you, sir, for giving your valuable time. I would like to welcome and extend thanks to Vice Chancellor, Sir, and Registrar, Sir, of ICFAI University, Dehradun. Also, I welcome Dean of ICFAI Law School, Professor Dr. Yugul Kishore, Sir, along with Academic Coordinator, Ms. Monica Kharola, Ma'am, and all participants of the webinar. Moving toward today's webinar, I would like to call upon Dean ICFAI Law School, Dr. Yugul Kishore, Sir, to give brief introduction about ICFAI University, Dehradun. Over to you, sir.
Okay, thank you. Thank you very much, Mr. Parth Upadhyay ji. So, my esteemed learned friend, Mr. Nitin Kumar Gupta ji, a very senior advocate of the Supreme Court of India and a person who has been dealing with commercial cases in the Supreme Court of India for quite a long time, very experienced person. So, and all my colleagues of this university as well as from other universities and my student friends. Today it is a very important day that we are organizing a national webinar on Commercial Courts Act. So on this occasion, first of all, I would like to speak a little bit about my university. So this ICFAI University, Dehradun, was established in the year 2003 by an enactment of the Uttarakhand government, and the person who was instrumental in seeing that this university comes in is Mr. N.J. Yashasvi, who is having a great honor to have established 11 ICFAI universities throughout the country. And from that time, 4 schools are working. One is the law, the other is the business, third is the tech, and the fourth is the education. And here in this university, we have been trying to inculcate the quality legal education, which is having a proper bent of professional skill and research in it. And with the result that ICFAI Law School has been recognized as and ranked as the first in Uttarakhand and 6th among the top schools of eminence in India by CSR survey. India today has ranked us at 26 from among all NLUs, central universities, state universities, and private universities. Similarly, the others have also ranked us very well. And in fact, the ICFAI Law School has the honor to get a certificate from the authorities that E-Lead certificate. We are competent and capable in e-education and in law, and university is having a very good rank as far as the 44 rank in URI. That URI is called World University in Real Application by United National Institute of Training and Practice. So this way, university is also having a good repute, and we are also having a good repute. Now, one or two words with regards to the topic. Today's topic is very important. You know, in India, cases are delayed, and further delay denies the justice. Delay defeats the justice. We all know. So therefore, under the commercial law, under commercial cases, when delay was there, so it has created a lot of problem, and India got a very bad rank at the ease of doing business at the world level. And in this era of globalization, privatization, and liberalization, this ranking has a very bad impact on us. So therefore, in the year 2015, the Commercial Code Act was enacted in order to give a speedy judgment in the commercial cases at all levels, at the level of lower judiciary, at the level of district judge, at the level of high court, and therefore this has become a very, very important act as far as the commercial cases are concerned. And today, fortunately, we have a very, very eminent speaker who is here to give you a proper insight and knowledge in this particular act. So before he is invited to speak, I request the academic coordinator of ICFI Law School, Madam Monica Kharola, to please give a brief introduction of our chief speaker of the day, Mr. Nitin Kumar Gupta ji. Madam, please.
Thank you, sir. Thank you, sir. It's my privilege to introduce to all the participants the speaker for this webinar. We have with us Gupta is a renowned advocate of Supreme Court, and he also practices in the Delhi High Court. He obtained his degree in law from Indraprasth University, Delhi. And after getting enrolled as an advocate, he has started practicing in the Supreme Court. He is also the founding partner of a renowned law firm called the Sunraj Law Associates and Solicitors, which has a pan-India presence through its associates. As a counsel, Mr. Gupta has appeared before the Apex Court in many important cases like the Delhi Medical Association versus Principal Secretary Health, and also the Dr. Sanjay Kumar Yadav versus AIIMS Delhi. He has continuously and consistently been appearing before the higher courts. Moreover, Mr. Gupta has also been appearing before the National Consumer Dispute Redressal Commission and also the National Company Law Appellate Tribunal, the Central Administrative Tribunal, and other appellate judicial forums. He has also been empaneled as an advocate with many private corporations like Asian Paints, OLX, Grofers India Private Limited, Cashfree, etc. Mr. Nitin Gupta has been appearing as advocate from the Bar Council of Maharashtra and Goa also. He has wide experience in commercial litigation. We welcome you, sir, and hope that our students will benefit from your lecture. I hand over the mic to you. Thank you.
I first of all want to start by thanking the ICFI Law School for giving me this opportunity. And I want to place on record my appreciation for the VC sir, for Professor Dr. Yugal Kishore, Mr. Dean, Monica Kharola ma'am, and Parth Upadhyay. It is indeed an honor to share my whatever little knowledge and experience I have with regard to the topic we are discussing today, the Commercial Codes Act, with all the students and all the members who are attending this webinar. I hope I'm audible and clear to all the participants.
Yes, sure, sir. You are very much audible.
To start with, I would want to place on record two things. I would want all of the participants to focus on the practical side. With regard to the academic side, you all are in the able hands of your faculty and your teachers, who will definitely be taking you through the nuances of this new act. I will say new act because every act takes its time to formulate, and then the principles are decided by the judges up to the Supreme Court on how to interpret the law. So when I say that I'll be focusing on the practical side, so that why I say that is so that you people can get an insight on what lies ahead in this area of law. So second thing which I'll be doing is I will be sharing what was the situation before the advent of this act of commercial courts and what is it now. And I will end my note sharing briefly on what is the road ahead. Because honestly speaking, law is one thing, the execution is another. All the youngsters, all my young friends, the way the judiciary and the Indian legal system is going to work depends on what we are accustomed to and how we take things forward. And that is where law school, especially like ICFI Law School, comes into the picture, the legal education and then the practical aspect. So without wasting time, I will give a brief note on what was the situation before the coming into of the Commercial Courts Act. The act when it was brought into force was not known as Commercial Courts Act. It was noted as Commercial Courts, Commercial Division, and Commercial Appellate Division of High Courts Act 2015. Later on amended in the May of 2018, and now it comes to be known as the Commercial Courts Act. All of us have come across, even before we joined law school, all of us have come across instances where we have seen cases lingering on for years and decades altogether, especially the civil suits. So the Commercial Courts Act is a bifurcation, or I shall say, carving out certain civil disputes and which are in the nature of commercial dispute and putting a special legislation for their trial, for their expeditious trial. So the situation before the advent of this act was all the civil suits in India, by and large, have been governed by the procedure as laid down in the CPC. The act is of 1908. Now everyone would assume that 1908 Act till date, we have been doing our civil disputes and following the procedure which have been enacted in 1908, of course, with amendments which have come from time to time. And I will say this with huge humility and respect, that this code has been subjected to much of abuse for delaying the civil suits. And that is why we have been hearing instances of civil suits lingering on for decades. This code did not provide for a specified timeline for completing the trial of a civil suit. It had various provisions which were subjected to abuse by the bar and by the bar in delaying the matter for various vested interests. However, the legislature did not keep its eyes closed to that. The legislature, especially after the privatization of the Indian economy in 1991, has been working on it. In 2015, as Dean Sir rightly mentioned, the Indian economy, after its opening up, has also been keeping an eye on the ease of doing business, especially with the coming in of FDI. Now, why this need arose all of a sudden? As far as globalization is concerned, all the people who are investing their money in India, all the foreigners who are investing their money in India, the foreign companies, whoever comes to India for business, the first thing they want to see is that when there are going to be transactions, there are necessarily going to be disputes. Where they stand in case there is a dispute with respect to their investment? How safe is their investment? How safe is their business? That is the ease of doing business. To improve their ranking, and as per the statement given by the Honorable Law Minister in his speech, he says that India aims to get into the ranking of within 50 in the ease of doing business, especially with the amendments which were proposed in 2018. Now I'll be coming to that as well further. So pre-Commercial Courts Act era, now if I may say so, era, it was something which was marred by the delay in the trial of proceedings. Now, what did the Commercial Courts Act did? So there are three objects, there are three reasons which the Law Commission in its 255th report specifically stated, why do they want to bring a legislation like Commercial Courts Act? And I must say that Law Commission in giving its reasons was quite up to the mark and was very reasonable in stating so. The first reason given by the Law Commission was, in its report was, it promotes economic growth. Now, you can correlate it with the ease of doing business. So for promoting the economic growth, the legislature identified that there's a need for fastening the process for commercial disputes disposal. The second, which they say, and if I may say that many of you may have your different views about the reason given by the Law Commission, is improving the international image of the Indian judicial system. Now, this is something which I would not elaborate on much, but I will leave it to your imagination. So a very interesting reason, by the way, improving international image of the Indian judicial system. And the third, which all of us, and I would invite my younger friends to ponder upon, the third reason, very important one, improving the legal culture. Now, what is a legal culture? Legal culture is what is we made out of the legal system. Now, that's the culture, that the culture which we learn, which we learn from the law schools, the one we learn when we do our internships and trainings under our seniors, the culture which we develop when we start our own individual practice. So this is the culture which we need to focus on. And this act seeks to bring about a change in the legal culture of this country. And I must say that we all have to be very responsible in handling this legal culture. Now I will come to the act. What is this act about? What is the act? How it is different and what happens after its enactment? CPC, as a procedure for the trial of civil proceedings, lays down exhaustively procedure for every step, which is in the manner of filing of a plaint, in the manner of filing a written statement, the timelines for it. Then what happens after the filing of written statement, filing a replication. There is no specific provision, but it's a practice which is being followed, filing a replication. Thereafter, the filing of evidence affidavits, admission and denial of issues. Now, all these things, some of you might have read CPC, some of you might be about to read CPC. So whatever I'm sharing, you will learn it, or you must have learned till now when you read CPC. So about the admission denial of the issues, thereafter the leading of the evidence by both the parties, cross-examination by the counsels of the parties of the witnesses, thereafter leading the, after completing the evidence, the final arguments, and thereafter the appeal stage. In CPC, there are appeal against orders, there are appeal against decrees, and there are also appeal against appellate orders as well. So this is by and large. So since today's topic is concerned with the Commercial Courts Act, I just wanted to give you a bird's eye view on how the things are with the CPC. Commercial Courts Act does not interfere in any of that. It lets all these things happen the way they are happen. The only thing which is happening is the procedure and the manner in which these things are done. They have undergone a change. Now, what is the act and what are those changes? The Commercial Courts Act, by its section 2, first of all defines what are these commercial disputes. So for you, I would also say that if some of you are interested, you can also take notes. I will be telling you about some sections and some provisions and maybe one or two judgments on how the judiciary has also interpreted regarding some provisions. So when you talk about section 2C, what are those commercial disputes? So the legislature in its wisdom has given a very exhaustive list of 21 categories of such cases which fall within the commercial disputes. These are the disputes which concerns with the mercantile law, about the bankers, financiers, traders, about the Carriage of Goods Act, shareholders agreement, licensing agreement, franchisee agreement. It also talks about the maritime law. it also talks about the joint venture agreements. So the very definition of commercial dispute has been included, has been explained in such a manner, has been enacted in such a manner that no dispute which is of a commercial nature can be maintainable or can be filed in a non-commercial court. So the first basic premise of a Commercial Courts Act is identifying whether the dispute is a commercial dispute or not. For that, Section 2C will help in identifying the said thing. A very special note I want to make here is, in all our studies and even in our practice as advocates, whenever there is an issue concerning a state authority or a government, we always think of our probable legal recourse is a writ jurisdiction. Whenever a state authority is involved, we talk about approaching the High Court under a writ jurisdiction. Whereas in Commercial Courts Act, within the Section 2C itself, the legislature has mentioned that even if the party involved is a state and if the dispute is of a commercial nature, the commercial court will have jurisdiction to entertain the commercial dispute, irrespective of the party being a state authority or not. Now, how important is this from the practical point of view for a lawyer? Every time a client approaches, whenever a state authority is concerned, the natural inclination is, and the natural provision is under Article 226 and 227, approaching a high court jurisdiction, or could be Article 32 if it's of a national importance and it's maintainable under Article 32 before the Supreme Court of India. Now, a commercial dispute which involves a state authority, and with what I'm about to tell, how the functioning of a criminal court happens, the lawyers have been given an additional legal recourse in resolving their dispute to the commercial courts. That's how it becomes important from the practical perspective. Now, let us talk about the structure or constitution of the commercial courts. Now, there are 4 categories which have been identified by the legislation. The first is a commercial court, which could be up to the level of a DJ. Now, every state has to establish a commercial court within its territory, and that commercial court will have jurisdiction, original jurisdiction as per the respective applicable laws, whether it will go before a district court or whether it will go before a high court. So when we say high court, there are 5 high courts in this country who have been given original jurisdiction, like Delhi, Madras, Calcutta, and Jammu, Kashmir, and Himachal Pradesh. So these are the 5 high courts which have been given original jurisdiction. So since I practice in Delhi, by and large, so Delhi High Court has pecuniary jurisdiction for commercial disputes, all disputes which are over and above 2 crores of value. So there is a commercial court. Then the appeal from a commercial court goes to a commercial appellate court. Then there is a commercial division. Now, what is a commercial division? Commercial division is a single bench of a high court which is designated as a commercial division. All the suits in these 5 states which fall above 2 CR, especially for Delhi, other high courts will have their respective pecuniary jurisdiction. This commercial suit has to be filed straight away before the high court. Now, a single judge of a high court is designated as a commercial division. The appeals from the orders and the judgment of a commercial appellate goes to the commercial appellate division, which is a division bench of the high court. So there are 4 categories: commercial court, commercial appellate court, commercial division, and commercial appellate division. So this is the structure which has been constituted under the Commercial Courts Act 2015. Why now, if you notice that I mentioned the appeals from commercial court will go to the commercial appellate court and appeals from commercial division will go to a commercial appellate division. Here itself, I will explain it in detail in a little while, but I will just touch upon the point. Why I say 1 appeal is because this act limits the number of appeals which can be filed to 1 appeal, which is not there in CPC. Second, what it does is it also limits the nature and the number of orders which can be appealed as passed by a commercial court or a commercial division, as the case may be. So, since we have covered the constitution of commercial courts and we are moving towards the procedural part, none of us would have heard about a term called case management hearing till now. This act, by its amendment to Order 15A of the CPC, brings in a new concept. Now, what is this? This concept talks about whenever a commercial suit is filed, there has to be a schedule which has to be finalized by the commercial court in consultation with the advocates for the parties. And what is this schedule? This is a schedule which concerns when the evidence of the parties will be filed, when the cross-examination of the witnesses will be done. The third thing which it seeks to cover is that when will the written arguments of the parties be filed and when will the oral arguments be heard, and it also allots a specific time for addressing oral arguments to each of the parties. Now, this thing was completely unheard of before the advent of the Commercial Courts Act. Now, this is what I wanted to touch upon. Now, I'll discuss this in detail as well. With Commercial Courts Act, the Act says a plaint which is filed before a commercial court has to necessarily and mandatorily contain the complete set of documents which are in the possession of the plaintiff on which the plaintiff relies. Now, this is something which was not there in the CPC, and the delay which used to occur previously when in a suits filed under CPC was there used to be various applications filed for taking permission to place on record certain documents, and some of those orders were appealed against by the opposite party if the application used to be allowed. If the application used to be rejected, then the party moving the application used to move in appeal, and that used to lead to a delay in the trial. With the Commercial Court Act, any plaintiff filing a suit has to give not only an affidavit, but also has to file a statement of truth, the format of which is provided by the Act itself. Now, what that statement of truth is, statement of truth contains the following things. It says the plaintiff is stating it on affidavit that he has filed all the documents which are in his possession. He does not wish to rely on any other document apart from that. He has signed on each and every page of the pleading which is filed as a plaint along with the documents. And these documents, once filed by the plaintiff, the plaintiff in ordinary courts will not be allowed to file any other additional document. And if that document is to be filed, it will be with the special permission of the court itself, and unlike the procedure which was followed earlier. Now, this is with respect to the plaint. Now, coming to the WS, the written statement. In the previous procedure, we have seen instances where the condonation of delay in filing of written statement over and above the time which has been given used to be allowed subject to cost. The Commercial Courts Act has defined and has given a time frame of 30 plus 90 days within which a written statement has to be necessarily filed, beyond which even the court does not have power to condone the time for the delay in filing the written statement. Now, why it is important? If the written statement which is to be filed by a defendant does not come within time and the courts go on condoning the delay and the party keeps filing appeal, it leads to a delay in the disposal of the suit itself. Once the Act has given a prescribed time of 30 plus 90 days and thereafter no provision itself of condoning the delay in filing the WS, it cuts short a lot of time for completion of proceedings. Now, the next stage which comes after the filing of the written statement is for the parties to file their admission denial affidavits and, of course, for the framing of issues. Now, what happens in a Commercial Courts Act? A commercial court, during the framing of issues, will also give, now, which I just touched upon, and why it is important is, it will create a timeline for all the things which are to happen now till the disposal of the suit. I'll say that again for your benefit. Under Order 15A, if any one of you wants to know, it is mentioned. I'll say what the Section 15A in this regard talks about. The Order 15A in this regard amendment talks about framing of issues between the parties, listing of witnesses to be examined by the parties, fixing the date by which the affidavit of evidence to be filed by the parties is to be done. Now, I'll just pause here. Why it is important? In my experience, practically, there are times when year almost a year passed just for asking the parties or making the parties file their evidence affidavits, which also did not used to come in one go. They used to come witness wise. Now, what Commercial Court Act does is that all the parties have to file the evidence affidavit of all their witnesses in one go. And there is a time which is fixed for that in the case management hearing. Now, this thing itself has reduced the time for the disposal of a commercial suit drastically. Thereafter, there is a timeline which is fixed under this order, amended order itself, for the witnesses who are to be examined, in how much time the witnesses are to be examined. And the act also says, the schedule also says that as far as possible, there has to be a day-to-day recording of evidence, which is not there in CPC. Now, if there are large number of witnesses, in our experience previously, the evidence itself used to take many years. Let us say there is a case which involves 25 witnesses, 10 witnesses from the other party, 15 from here. It will take years. That's not the case in the Commercial Courts Act. The commercial courts on the first date of case management hearing itself will fix a timeline, and they will ask their parties that they have to identify the number of witnesses who they'll be bringing, so that the court is well aware of the number of witnesses and the time required for recording their, for doing their examination. Once this stage is complete, now I have covered two stages till now. One is for the completion of pleadings, second is for the recording of evidence. In our practical experience, these two things itself have decreased the timeline for the disposal of the case at least by more than 50-60%. Now, there's no data for that, but I'm talking about my personal experience. The third aspect which comes after the recording of evidence is complete is the time taken by the parties in addressing the oral arguments, the time taken by the parties in filing their written arguments. What the Commercial Court Act does is, on the first hearing of case management itself, the court will also fix a date by which the parties will have to file their written arguments. The court will fix a date, court will fix a limit on which the oral arguments will be heard. The court will not just do that. The court will also identify and tell the time which will be allotted to each counsel of the party on how much time they will be given for addressing their oral arguments. Now, this in our experience was unheard of. This particular provision itself has streamlined not only the manner in which the case is going to be heard by a commercial court, but it also streamlines and gives a probable time within which a party can expect the case to be disposed of. In my view, this is one provision which needs to be very thoroughly understood and read by all of my young friends who are attending this webinar, to understand one of the most important changes which has been brought about by the Commercial Courts Act. Now, all of you must be thinking that we have heard about this, and we know that Commercial Courts Act have brought about drastic changes in decreasing the time for disposal. But there's something very important which the Commercial Courts Act did by its amendment in 2018. Commercial Courts Act makes it mandatory for a plaintiff to have a pre-institution mediation. As per section 12A of the Act, the mediation has been made an important part of the commercial suits. Now, what is this about? Whenever a party approaches a commercial court, there is a litigation which goes on. It could go on for a year or for 2 years or for many years. Act says that they have identified there are several instances where the disputes can be settled through mediation. Now, mediation, when I talk about mediation, is the mediators who are trained in this regard. So the party who wants to file a commercial court needs to approach the mediation center before the filing of the case. And if the case is settled, it saves both the parties from the litigation, and it also reduces the burden on the judiciary itself. One of the data from Delhi, which I want to share with all of you, is 62% of the cases of commercial nature have been settled in pre-institution mediation. Now imagine this 62% cases, had they been fought in the court, what would have been the figure for the pendency of the cases in the Delhi courts? This mediation, first of all, is confidential. This mediation is free of cost. Thereafter, it gives the party to resolve their disputes out of the court. Now, when I say confidential, even if a matter does not get settled in a mediation, the parties always have the option of going to a court, and any statement or anything said by a party in a mediation cannot be used by the opposite side during the litigation. So the mediation is always confidential in nature. The legislature not only devises this pre-institution mediation, the legislature has also given a timeline for finishing this pre-institution mediation, which is of 3 months, extendable by further 2 months with the consent of parties. So giving this timeline further makes the parties understand that even if that whenever they go for mediation, there is a certain timeline set within which they have to finish the mediation. Otherwise, the doors of the court are always open. I will just end on this section by saying one thing. Previously, for suits which are not of commercial nature and the other civil suits previous to the coming of Commercial Courts Act, a matter could be sent to mediation only when both the parties consented to their matter being referred to the mediation center. This act makes it mandatory. There's only one exception to it. Wherever a plaintiff is filing a commercial suit which involves an urgent interim relief, the plaintiff can go directly to the court and is not barred by this section to opt for pre-institution mediation. So when I talk about mediation, I just wanted to give all of you a brief idea about how the Commercial Courts Act is not only reducing the time taken in the disposal of cases, it is also providing a platform. It is also making the parties go to a mediation center and try and resolve the disputes. There have also been instances where the parties have been having dispute, let us say, on 4 issues, and 2 of them have got settled in the mediation center. It reduces the burden on the parties also, it reduces the burden on the judiciary also. So with this background, the importance of Section 12A is to be understood. The third important point for a Commercial Court Act, in contradiction to the CPC, in contrast, or I'll say in comparison to CPC, has to be understood is, in Commercial Courts Act, there is only one appeal, which is maintainable. So when I say one appeal, let's go to the provision and then we'll have a brief discussion about it. So as per Section 13(1)(a), I'll read the section for you and thereafter we'll have a brief discussion on that. Any person who's aggrieved by the judgment, I'm reading Section 13(1)(a), which is under Chapter 4 of the Commercial Courts Act. Any person aggrieved by the judgment or order of a commercial court at the level of district judge exercising original civil jurisdiction, or as the case may be, commercial division of a high court may appeal to the commercial appellate division of that high court within a period of 60 days from the date of judgment or order. The proviso to this subsection is very important. It says, provided that an appeal shall lie from such orders passed by a commercial division or a commercial court that are specifically enumerated under Order 43 of CPC and Section 37 of the Arbitration and Conciliation Act. This particular proviso and this particular section was the subject matter of interpretation before the Honorable High Court of Delhi in one of the cases which I'll be discussing. But this section limits 2 things. One, it limits the number of orders or the nature of orders against which an appeal is maintainable. It also provides for a separate limitation, which is of 60 days for filing an appeal against a judgment or an order, as the case may be. In CPC, this was not so. In CPC, there are different limitations for different nature of orders, and the CPC in its various provisions provides for different orders and how they can be appealed and to what extent they can be appealed, and the appeals against the appellate orders also. In the particular case of Commercial Courts Act, as I said, there are 2 distinct features. One is the limitation, which is specific to the Commercial Courts Act, and then the nature of the orders. Now, if any of you would, whenever you, all of you find time, please go through Order 43 of the CPC. That order lists the number of orders, the nature of orders against which an appeal is maintainable. Commercial Courts Act limits the orders to as enumerated under Order 43 of the CPC as the orders against which appeals can be filed. Now, since the act is new, it's in its infancy, there were several interpretations which were floating around, and the Delhi High Court had an occasion to deal with one of the matters by the name of HPL India versus QRG Enterprises. In its decision of 14th of February 2017, if any of you wants to write down, the judgment is by the name of HPL India Limited and others versus QRG Enterprises and another. Now, this is a judgment of the Delhi High Court, and this, in my view, in my opinion, authored by Justice B.D. Ahmed, lays down the interpretation for this particular section, which I just read, in a very beautiful manner. For all of your benefit, I would just want to highlight what is the interpretation given by the High Court and how it has impacted the time taken in the disposal of a commercial suits, because it categorically lays down what I just said about Order 43 being the only list of orders which are appealable became clear after this judgment. This judgment says that there are orders against which an appeal can be filed under CPC. There are orders against which, appellate orders against which an appeal or a revision could be maintainable. There are judgments and decrees against which an order can be, against which an appeal can be filed as per the CPC. The Commercial Courts Act makes all the provisions of CPC which are in contradiction to it as redundant. The Commercial Courts Act says whatever provision Commercial Court Act is laying down now after amending the CPC, that has to be followed even if it is in contradiction to the CPC. This particular judgment talks about why the party who has obtained an order as enumerated under Order 43 is entitled, and why a party who has obtained an order which is not enumerated under Order 43 is not entitled to file an appeal. There was also a plea raised by one of the parties that if those orders which are not under Order 43 cannot be appealed against, it would virtually leave a litigant remediless. The Honorable High Court was of the view that it is not for the High Court to step into the legislature's shoes and say that since the Act does not provide for an appeal against this particular order, the party will become remediless. It is for the legislature to decide, and it is for the judiciary to only enforce the Act. So this is the judgment under which the interpretation of only Order 43 orders as enumerated under Order 43 CPC are listed. They can be appealed against was clarified, and thereafter this has become the law as on date. Now, appeals, why I say is a very important aspect, is not just limiting the appeal to one, from commercial court to a commercial appellate court and commercial division to a commercial appellate division is important. Is previously what used to happen practically was whenever there's an order passed, though there used to be appeal against that, it used to somehow delay the original trial. The parties not only used to appeal against that order, but the parties could have opted for filing an appeal against the appellate order itself. This led to a further delay in the trial of the civil suits. But now what has happened after the Commercial Court Act is, with the limiting of the appeal to one, the parties know that their right to file an appeal is limited. The parties now know what are the nature of orders against which they can appeal. So not just the trial proceedings have been shortened, the appellate time, the time taken in filing of appeals and the disposal of the appeals have also been considerably reduced, which has led to the increase in investor confidence in investing in India. And that was the basic purpose and the object behind the enactment of the Commercial Courts Act. Now, let me discuss a few other things about the Commercial Courts Act. The Act, as per Section 8, also has a bar on the revision. Any revision which is to be filed is not maintainable under the Commercial Courts Act. The Section 8 of the Commercial Courts Act specifically bars that. And in CPC, this provision is available. The parties can opt for it. The reason behind, again, this is to cut short the time of the trial. Now, just to sum this up, Commercial Courts Act, by its very nature, is intending to, it has done, which has been a long-standing demand of the litigants and of the bar and bench. That is how to devise a way shortening the disposal time of a civil suits. Commercial Courts Act in 2015, when it came, it was limited to all the commercial suits which were over and above 1 crore rupees. With the amendment of 2018, this has been extended to all the disputes where the value of dispute is more than 3 lakh rupees. Now, by doing this, what the legislature has done is it has virtually brought almost all the cases of commercial nature to be decided by a commercial court. Now, there's one note of caution which I just want to say, that whenever I say that this has reduced the time, we also have to keep into on the back of our mind, we also have to understand that the burden on the judiciary remains the same, because what this act has done is it has not created it has not added on the number of judges. What this act has only done is that out of the existing lot of the judges, some of the judges and some of the courts have been designated as commercial courts or the commercial division, as the case may be. So this will be a very determining factor in the time taken by the parties, in the time taken by the courts to get a civil suit disposed of. The second, what it does is, the second thing which needs to be done, and here I want to speak about the legal culture which I emphasized upon in the beginning. It is not just only upon the judiciary. As the officers of the court, as lawyers, it is also our bounden duty to ensure that the objective behind the enactment of this act should be fulfilled. If we as lawyers are going to adhere to the schedule which is defined by the judge in the case management hearing, if we are going to follow this act in the letter and spirit, I am telling you, in practicality, it will reduce the time taken in the disposal of the civil suits. And this is not just beneficial for a lawyer as a practitioner, but it will also lead to an increase in the confidence of the litigants which they have on the Indian judicial system. Of course, about the foreign investors as well. So with this, I will sum up about the Commercial Courts Act. But let us have a little bit of insight into what lies ahead. See, legislature has done its duty of enacting a law as per the demand for reducing the time in the disposal of the commercial suits. And legislature has also been considerate enough in considering the reducing the pecuniary jurisdiction to bring about all the suits of commercial nature within the ambit of the commercial courts. What is the road ahead? See, it is, as a lawyer, I'll talk about it as a lawyer. It is our duty, first of all, to identify the nature of the case which a client brings to your office, whether it's a commercial case or not. Because we have to keep in mind that all the commercial contracts are very important to the parties. Otherwise, there was no need for enactment of a specific commercial court. The legislature identifies it. As lawyers, as officers of the court, we also have to identify that. Thereafter, it is our duty. What is the road ahead? It is our duty to ensure that we adhere to the terms, to the practice, the procedure which has been identified in this, to fulfill the obligation which falls upon us as a lawyer, as defined by the court, which needs to be taken into consideration if the case has to be disposed of early. Thirdly, not becoming a part of the fraternity where we are abusing the provisions of the law just to delay the case. The enactment itself will fail. The objective itself will fail if we are not going to keep into consideration the responsibility which falls upon us as a lawyer, as an advocate, as an officer of the court in fulfilling this. But there is, since the Dean Sir was kind enough of, putting some words for us, I just want to mention that this particular enactment is in its infancy. There are various cases which have still not reached the stage where the provisions, what they appear to be or what they actually mean, could be subject matter of judicial scrutiny in times to come. The Supreme Court has also got very few instances where it has opportunity to deal with the commercial courts, because as the suits get decided, as the appeals reach the High Court, thereafter the Supreme Court would also have an opportunity to look into the matter. And when I say one appeal, I just want to add one more thing. When I say one appeal, that is what is provided by the Act. The second appeal is not per se an appeal. It's a legal recourse under Article 136 of the Constitution of India, where any order against which no appeal is maintainable or where any party is aggrieved, they can approach the Supreme Court in a special leave petition under Article 136 of the Constitution of India. So the high courts which have a original jurisdiction with respect to this, as I mentioned, 5 high courts, they have also created a separate commercial division. And in my view, practically the way the civil suits are being conducted by the commercial court, it is unlike what we have seen till now. And it falls now as younger, my younger friends who are going to be a part of the, bar very soon or in time to come. It is also our duty to take this responsibility and fulfill the objective, which is going to be good for the image of our fraternity and for the Indian judicial system. So with this, I would like to end my this submissions, and I would hand it over to the management on how to take this forward.
Thank you very much, sir. Thank you very much for giving a deep insight about the topic. And sir, we have some questions from the students. One student is asking that, is there any maximum prescribed period for the disposal of commercial cases?
So as per the order 15A, sub rule 3, it says the court shall ensure that the trial of a commercial suit is finished within 6 months from the date of first case management hearing. Okay. Now, I would want to add a word of caution here. See, almost, we might see that there are timelines framed in almost all the legislations. Could it be, it could be Consumer Protection Act, or it could be like this instance. But since the Commercial Courts Act have, started coming up and they are dealing with cases, and there are also the pending cases which were of commercial nature, which have also stood transferred to the commercial courts now. So the timeline which is fixed by and large is being followed. But let's not have very high hopes of, that this timeline as stated by the Act will be, adhered to in letter and spirit. There is an effort by the judges, there is an effort by the bench and the bar, and the suits are by and large happening in the way they are supposed to happen.
Okay, sir. Thank you, sir. Sir, one more question.
Yes.
Can a pending case in any civil court get transferred to the commercial court if the matter is pending before the enactment of this act?
Yes. So the act itself says that all the cases which are of commercial nature, they have to be transferred to the commercial court. The act itself says, I'll just tell you the provision itself, which says that all the cases which are pending of commercial nature have to be transferred. And in fact, that has even been carried out, by the all the courts. I'll just tell you the provision itself.
Thank
There
you,
was,
sir.
in fact, it's section 15 talks about the transfer of pending cases. Yes, please.
Okay, sir. Thank you very much, sir. Now, I would like to call Miss Monica Kotial, ma'am, to give vote of thanks.
Thank you.
Sir, it's an honor for me to give a vote of thanks to a learned speaker of the Supreme Court, that means advocate of the Supreme Court, I'm sorry. So thank you for enlightening us with the brief introduction and the explanation of the commercial courts and the act, which is a new act in the legal system also. So thank you so much, sir, for giving us this brief introduction. And I would like to thank you for enlightening us and giving all these examples. With examples, you're giving the the explanation. And I hope all our participants would enjoy this session that you have given to us, as you have given all the practical experiences that is the actual practicality of this Commercial Courts Act. So thank you so much, sir, for giving this session. And I would like to thank our Vice Chancellor, sir, also for giving this opportunity, and our Vice Chancellor, Dr. Mudhu Vinay, our Registrar, sir, Brigadier Rajiv Sethi, sir, and a special thanks for our Dean, sir, that is Professor Dr. Yugal Kishore, sir, and our academic coordinator, Ms. Monica Karola, ma'am, for supporting us. And thank you, Mr. Path, for connecting to the learned speaker and giving us the important information that we require in this new legal system. And thank you, Akhilesh sir, for giving all the technicalities and for resolving all the technicalities in the Zoom platform. Thank you, Mr. Nitin Kumar Gupta sir. We are very fortunate to have you here in this platform in our ICFI University. On behalf of ICFI University, I would like to thank you so much for giving the detailed everything about this, the Commercial Codes Act. Thank you,
I
sir.
myself want to thank for giving me the opportunity to share my whatever limited experience I have on this app. Thank you so much.
Thank you, sir.
Thank you.
So I also thank you, sir, very much for for devoting you so much of time and enlightening us on a new enactment. And we will also like to associate you with you in other aspects. And whenever this Corona pandemic is over, so then we will request you to visit our university and enlighten our students face to face. With that,
It will
thank
be
you.
a pleasure. It will be a pleasure, sir. Thank you so much for giving me the opportunity. Thank you.
Thank you.
Thank you, sir.
Thank you, sir.
Thank you. Now we can close down, isn't it?
Yes, sir.